Okay, we're going to get started. It's about a few minutes after 8:30, about 8:33, and got a little late start. Had to do some adjusting on the computer. And it is Tuesday, May 28th, 2019, and welcome to week 4 of Introduction to Criminal Law. And I'm Professor Wright, and we're going to go over the details for this week's assignments. And then I also want to point out to you that starting this week, at the end of this week, assignments for week 3 will not be accepted by the time we get to the end of this week. However, weeks 1 and 2, it is too late to submit those because you're beyond the period of time that even the late requirements are as set out in the syllabus, which is 7 days. So the point of the matter is that each day, though, that week 3 is already, at this point, if you submitted it, 2 days late because it was due Sunday, and it is now Tuesday. So by the time you get to the end of the week, you'll get hardly any points. So unless there were some extenuating circumstances that I established with you, and we've discussed it, and we had already set that up. But at this point, I know of none except those that I have communicated with, and you know who you are. So let's go ahead and let's share my screen, because basically we are in the second half of the course. And so here's details that I'm familiar with. Again, reminding you that rubrics are located with each written assignment, and also to remind you that your recordings are found here in this section for weeks 1, open house, week 2, week 3, and then after today, this afternoon, or this evening, tonight, or early tomorrow, you'll have week 4. And you'll see here that we have just 2 more lectures, weeks 5 and week 6. Okay? And I'm going to go to the week 4 announcement. Let's open it up. So today we're going to talk about crimes against government and public order. For the last couple of weeks, we've been talking about crimes against property. That was week 2, and crimes against persons last week. So this week, crimes against the government and public order. Module 4 is about that. And so you were to read in the textbook, A Brief Introduction to Criminal Law, Chapter 8. I also sent you the PowerPoints previously. And then we go over the activities: domestic terrorism, obstruction of justice, resisting arrest, fleeing police, disorderly conduct, free speech, and then take a look at some of these things that help you to get ready for the quiz. Be sure to participate in the discussion assignment, which is due tonight by 11:59 p.m. Central Standard Time, obstruction of justice. And then, of course, you know Saturday that the reply post is due. And you know my rules about those posts at this point. Finally, be sure to complete the written assignment, fleeing or eluding police. And that's your written assignment. We're going to talk about that in a minute. And then there is a mid-quarter survey that we ask you to complete, and please submit it as well. And it's anonymous. And then you know about my motto, adversity is the springboard to success. Let's take a look at the course calendar. Course calendar is right here. This tells you where we are right here, the 28th. And then your written reply posts are due on the 1st. Notice that we'll be going into June. And then your written assignment is due on the 2nd. On the 2nd. Now, remember I said that practice quiz last week you had this week was only 6. But this Sunday, you're going to have one written assignment, and then you have to give the key word. All right? And so we're going to tell you, we'll look at the rubric for that in a minute. But you can see by looking at this. Let's go over to June so you can see what I'm talking about. So let's hit this. That's this week, right here, leading up to Sunday. And you'll see that we have just one more Sunday left in the class, and that is for week 5, which we'll cover next week. And then the final day of class is not the following Sunday, the 16th, but the 14th at 11:59 p.m. Central Standard Time. You cannot say you didn't know, because I've given warning ever since the beginning, and then I'm going to click on this, and there it is. The quarter ends at 11:59 Central Standard Time on the 14th. You'll also see that in your announcements as well. So that's your course calendar, all right? So now let's go into the module for the week, and let's take a look at the assignments more in detail. So your discussion, obstruction of justice, you have this fact pattern that you're going to consider, and then you're going to base your initial post. Then you're going to be familiar with the Terry stop, the pat-down stop. It's called Terry versus Ohio, and you can click on that and you can find details about it. And then you're going to answer each of these questions. Some of you have already started answering them. All right. Then for your, it's going to be dealing with these issues, but you're going to have a scenario for part 1, and you're going to deal with this scenario and apply it to the minimum of 2 pages, not counting the cover page, double space, by the way, and with citations in the body and references in the end. So it says, if you use your textbook to research the elements, include a reference page, which you will, APA citations, and the other APA formal requirements. Be sure to cite the sources. Try not to rely too much on the textbook. The idea is for you to conduct research. So you're going to deal with each of these issues in your paper. You're going to take a look at these policies, the sample police pursuit policy, and then the case of Brower versus County of Inyo. You're going to look at that. And then you're going to create a flyer. And then you're going to follow each of these steps, and it tells you what to do. There is a template that you need to use as well. And then for purposes of research, again, we have the guides, and you can find all the information concerning APA, tutoring. Make sure you run your papers through Grammarly. All right, I don't have to tell you about the zip files. You know how that works. Some of you don't do zip files. It's okay. You can attach both to the assignment if you want. Either way, it's okay with me. So 40 points for the assignment due Sunday. Here is the all-important rubric. And you're going to follow what it says here. And it tells you what you have to do. And it's 2 pages. It's 2 pages. Make sure you conduct research. Use reliable, credible sources. And you're going to deal with these issues. These are the same issues that are in the module itself. And then you're familiar with these 2. These sections are the same throughout the whole course. And then your flyer, 1 page length requirement. And you deal with the issues that are listed in here. And that's what you need to do to get your 40 points. And you need to get it in on time as well. Okay? If there's any issues or concerns, reach out to me. You know the rules about reaching out to me. and I'm not going to go over them, but you know what they are. And then you're going to submit your live classroom key phrase that I'm going to give you near the end or some point during this lecture. Usually I mention it more than once, but I clarify it at the end. And then complete the mid-quarter survey. Again, it's completely anonymous. It helps us in terms of the course itself. All right. So now let's go into a section that you should be looking at yourself, lesson content, and this is where I'm going to talk to you about the various issues. I'm going to talk about domestic terrorism, obstruction of justice, resisting arrest, fleeing police, and then I'm going to conclude with disorderly conduct and free speech. So let's start up talking about domestic terrorism. First of all, when you say domestic terrorism, we are talking about terrorism that takes place domestically in the United States of America. Probably one of the first forms of domestic terrorism took place years ago in Hawaii, and that was Pearl Harbor. And, you know, that resulted in World War II. Then the one that really triggered it on the mainland within the territory of the United States was the September 11th attack. And out of that, there came the Homeland Security and then the Patriot Act. Now, prior to that, there was also some domestic security terrorism issues, and that was the Oklahoma City bombing that took place. I believe, I'm trying to remember, it was in 95, I believe it was, around that time. But anyway, what we're talking about when we're talking about domestic terrorism, as the FBI describes it, who investigates it here in the United States, the use of force against any person or property to intimidate the government, the civilian population, or any segment in furtherance of a political or social objective. There have been some things that have happened in this country that organizations like Al-Qaeda or there are other organizations that have claimed that they were doing these acts in the name of a government or against the government, but resulted in injuries and deaths to individual citizens. And so ISIS, they talk about, or any organization outside the United States. So it could be targeted, as they say, at a specific cause or at an entity, such as state-sponsored terrorism, which is a terroristic act by a state government. Now, that is an argument that takes place about what happened September the 11th, and they said that that was exactly that. However, it doesn't matter. It's still violence that results in mass destruction domestically within the United States. So, international terrorism, on the other hand, is something that takes place outside of the United States. And the United States Criminal Code, which is 18 United States Code, I forget which section this is in, but it says international terrorism is an act dangerous to human life that occurs outside the U.S. or on U.S. soil by foreign terrorists. So we're talking about the fact that this terrorism can take place here like the September the 11th, but it can also happen in other parts of the world where it is a attempt to, as I say, adversely affect the United States government or its members. It happens at embassies and other places. It says that is a violation of the criminal laws of the United States, and if it's committed within the United States or any jurisdiction in the United States, that appears or is intended to, and here's the part where we get into the terrorism aspect, to intimidate or coerce a civilian population, or to influence the government policy by intimidation or coercion, or affect the conduct of government by mass destruction, assassination, or kidnapping. And it's been said that some of our political leaders have been assassinated or killed in the name of those kinds of activities. And so it talks about here that the attack that happened during September 11th is an example of international terrorism because they were carried out on U.S. soil by a foreign terrorist group, and that's the point. So the whole point in a nutshell is that when it happens in our country or outside our country, and it reaches the stage where the violence is used to intimidate the government or try to force the government to do something, that's when we start talking about terrorism. So talking about domestic terrorism, who are, it says, is carried out by terrorists who are from within the country and carry out attacks against fellow citizens, government, or any segment. And an example of that is the Oklahoma City bombing that I was talking about, that they refer to here. Another example they refer to is the Olympic Park bombing, where Eric Rudolph targeted anti-abortion clinics between 1996 and 1998 and resulted in 2 deaths and injuries to more than 200. We can talk about other forms of domestic terrorism. What happened in Las Vegas, what happened down in Orlando. These are instances. But yeah, it was in 1995 that the Oklahoma City bombing took place, where 2 American citizens, Timothy McVeigh, and I forget the other person's name, but a large truck bomb, and it resulted in the death of 168 people and injured more than 600 women and children. In fact, in that building, there was a daycare that resulted in the death of so many children. And the idea that McVeigh and his partner, I can't remember his last name, motivation was to avenge the handling of an earlier incident at Ruby Ridge in Naples, Idaho, where a federal agent was killed with a 14-year-old child. So Timothy McVeigh believed that the Ruby Ridge incident was improperly handled, and that's what he did. He took steps against the government, and that resulted in the Oklahoma City bombing. So who investigates acts of domestic terrorism? All levels of government, the federal level, the state level, the county level. But and they all come together to investigate. That's the FBI. Now we have the Homeland Security, and they talk about what happened and how Timothy McVeigh was stopped in Oklahoma. A state trooper, stopped him for a minor traffic registration violation and apprehended him for the bombing. Eric Rudolph, who dealt with the Oklahoma Park bombing, was also apprehended by a patrol officer. So the point of the matter is that all aspects of government work together to attempt to apprehend individuals who commit these types of activities. And we are at a stage now where because of what happened in Oklahoma City, but specifically what happened September the 11th, that we as a country have different kinds of alerts that we watch out for, because of the fact that we're at a stage now where there are so many activities that organizations, even with anything that happens on a high level, some governments try to claim some responsibility. You remember the one that happened out in California I can't remember the name of the city where the two people were killed that did it, but they were supposedly involved with some foreign government as well. But the key thing to be aware of is that we are in an era now where violence is taking place in such large numbers that we find ourselves having to adjust to that in our travel, in going to public events like sporting events, whenever there is a parade or anything where large groups of people come together, and then especially on high alert during holidays like Memorial Day that just passed, like the commemoration of September 11. And by the way, just so you'll know, 911, it happened, was designed because of the fact that they were trying to bring emphasis to 911. And you know what 911 is. 911 is an emergency situation. And so that's what that was all about. And so there are people now, even as we are speaking today, that are sitting by the wayside waiting for an opportunity to do something to make their names big. I would even go so far as to say we're talking about terrorism in our country. You have some of these people who come into the schools now to commit shootings. And so we find ourselves, again, well, we have to be on high alert, and we have to watch over every event that we have. So now I've said what I need to say about domestic and international terrorism. I want to move on to the next topic, and that is obstruction of justice. So what is obstruction of justice? Simply not telling the truth, concealing information, misleading law enforcement authorities, or doing something to prevent an investigation from going forth. A lot of times people harbor individuals that are a warrant is out for them. That's an obstruction of justice charge. And it can happen actually in court, or it can happen outside of court. So let's talk about how obstruction of justice happens in court. Very simply, most of the time, it's simply not telling the truth on the stand. We call that perjury. When you willfully take the oath or affirm during a court proceeding, or you find yourself also with the same thing in congressional hearings, official government hearings, and you do the same thing. That is perjury. And it's lying, but it's not just harmless lying. It is an act where you are covering up justice or an attempt to get to the truth and leading the system to believe something is true when it's not. And so that's called perjury, and you can go to jail for that. Remember, the whole thing is that when you're not telling the truth and you're under oath, that's when you find yourself dealing with perjury. Now, if you're not under oath or you haven't affirmed, then in that instance, it's not the same thing as perjury. So perjury comes as a result of, because when you go in, you say, "I do solemnly swear to tell the whole truth, nothing but the truth, so help me God." Basically, what you're doing is you're leading the trier of fact to rely upon your statements as being truthful. If you, for a fact, contradict yourself, not make a mistake, it's a difference in making a mistake and perjury. It has to be knowingly, and you withheld information or you didn't tell the truth about something, and then it's determined that you did not tell the truth, then that's when perjury kicks in and you can go to jail. Obstruction of justice on the streets is when somebody deliberately, as they say, just very simply mislead the police. And in a number of things. It says people are not required to talk to police when they're questioned, and you know that, right, because of the Fifth Amendment, and provides protection. However, if you choose to answer a question, then you need to tell the truth. Otherwise, you can be charged not with perjury, but with obstruction of justice, because the law enforcement people are going to rely upon your statements or information in their investigation. Now, that's kind of what happened, as everybody knows all about what happened with the Jussie Smollett case. And in the Jussie Smollett case, he alleged that he had been attacked, and there was a mass investigation that took place, and then later on, it became clear that he had submitted what they charged him with as false reports. Of course, you know, later the charges were dropped, but my point being is this, is that if it's determined that you're not telling the truth in a police report, or you're making a false report, anything like that, where you're misleading the authorities, that is another form of obstruction of justice. If you are on the streets and you are stopped and asked for your name, and you tell someone that your name is another name, sometimes legally that's obstruction of justice. However, what will usually take place there is that you can find yourself in a situation where you've created a bad situation for yourself, because if you end up getting arrested, that name is going to be used to demonstrate that you tried to mislead the police. So look at some of the examples here. Lying to police, deliberately misleading police. Look at the Kansas state statute that we have here in our module here, and it talks about anyone who prohibits obstructing and states that or interferes or obstructs or falsely reporting to a law enforcement officer, agency, or state investigative agency that a person has committed a crime, knowing that such information is false, and that the office or agency shall act in reliance upon such information. That's kind of like what I was talking about with the Jussie Smollett case. There's been other instances in the news recently, false kidnapping cases as well. Another is that law enforcement has committed a crime or committed misconduct in the performance of their duties, knowing that such information is false and intending that the office agency act in reliance upon such information. Again, false reports that police officers can write can also result in obstruction of justice. Any kind of false report. Any information knowing that such information is false and intended to influence, impede, or obstruct an agency or the agency's duties is obstruction of justice. Any information concerning, listen to this, the death, disappearance, or potential death or disappearance of a child under the age of 13, knowing that such information is false, intending that the agency relies upon that information, is also obstructing. What you basically see is a pattern of covering up the truth. That's what it amounts to. And then concealing, destroying, or materially altering evidence to prevent the apprehension or prosecution of a person, or to place a person, make a person appear to be guilty when in fact they did not commit an offense. Same kind of thing, obstruction of justice. And then finally, knowingly obstructing, resisting, or opposing any person authorized by the law to serve process. And this is what I was talking about earlier, where you try to get a person, hide them away so that they cannot be served with a warrant or writ or any other kind of process or court order. And so here's an article which we're not going to take time to read, but you can take time to read this on your own. So obstruction of justice leads pretty much to the clear understanding, even with this Ohio statute. Says no person who is in a public area shall refuse to disclose their name, address, or date of birth when requested by law enforcement who reasonably suspects either that the person is committing, has committed, or is about to commit a criminal offense, or the person witnessed any of the following: an offense of violence that would be a felony offense that would result in and create substantial risk of serious harm to another person, any attempt or conspiracy to commit or complicity in committing any offense listed above, and any conduct listed above that has been and is being about to be committed. The key thing is that you have to tell the law enforcement officer who you are. That is not a violation of the Fifth Amendment. Now, that's what Ohio has. Not every jurisdiction has this on the books. So don't get to the point to say, oh, that's the law everywhere. You have to look at each state, because each state has difference. Because anybody in Ohio, and that's the place where the famous Terry stop case came about, where it says in Ohio, anybody who's engaged in or witnesses any actions outlined in that statute has to identify themselves to a law enforcement officer. And if you fail to disclose your personal information, that is your name, your address, date of birth, you can be arrested for a misdemeanor offense. And it says nothing in the statute requires individuals to answer or provide information beyond their personal information. So basically, name, address, and date of birth. And then the stop and frisk case, Terry versus Ohio, which you're going to use for your assignment for this week. All right. So, and in this case, just a little summary of it, it basically established the principle that upon reasonable suspicion that a person is about to commit or is engaged in crime, that they can be briefly stopped for what we call a Terry search. And the Terry search is not an invasive search. It is a pat-down, basically, to number one, protect the officer and or to discover if there's any contraband. Now, if there's something in your pockets that's bulky like a gun, and they feel a gun, then that will be a point to rise above the Terry stop and then place you under arrest. And for their protection, they can conduct a search, which is an exception to the warrant. So, but in the general Terry stop, you generally are patted down for weapons and things like that, or drugs or anything like that that's of a large quantity. Now, in the state of Wisconsin, though, temporary questioning without arrest provide police with the authority to stop, temporarily detain, and demand the name of the person or suspect being involved. And then it says, however, no specific provision within that statute compels people to identify themselves, and there are no legal ramifications for merely failing to identify. Failing to identify can be a factor that the Wisconsin police would consider, but merely refusing to identify is not specifically prohibited within the state like it is in Ohio. Okay. So the point of the matter is, it depends on the jurisdiction that you're in. Okay. So you need to look to see what states have the failure to ID laws or identify laws as they do in Ohio. And here's an article below that gives you more details on that, and you can take a look at that at your own leisure. The key thing that you need to be aware of is that you don't want to impede an investigation, but at the same time, you don't want to incriminate yourself either. So given your name, your birth date, and your address shouldn't be something that incriminates you, because it is determining who you are. That's all that really is. Not what you're doing, not even why you're there, or those things. When it gets to the point of start asking, why are you here, and some of that, then we're going beyond that. And it's simply to identify yourself. All right? So get that pretty clear. So what we talk about, we start talking about resisting arrest. Very easy to do. If you are under arrest. And how do you know if you're under arrest? I have said many times to my students, you know you're under arrest when you're not free to go. So resisting the police, once they tell you that you're under arrest, is stopping, doing something to struggle or battle, kicking, running, even any of those kind of things. If a person obstructs police, it says, an arrest is likely to follow. That goes back to what I talked about earlier. And when a person is placed under arrest, if you resist any shape, form, or fashion, that's called resisting arrest. All right? Now, let's talk about when arrest takes place. Explicit custody is clear and leaves little room for error. So when a law enforcement officer says to a person, you're under arrest, that's pretty clear, right? And then you're handcuffed and so forth and so on. Then you're clearly under arrest. However, getting to the point that I was talking about earlier, implicit custody is concerned with what a reasonable person would believe at the time of the encounter. When individuals reasonably believe that they are not free to leave, that's what I said earlier, during a police encounter, they may perceive that they are indeed under arrest. So the key thing is, and we always tell people, one of the questions you can always ask, am I free to go? And if the answer is yes, then you're not under arrest and you can go. And if you start to go, they can't just grab you and do that. But as soon as it's made clear either explicitly or the answer is no, you cannot go, and then you start trying to wrestle and that, then you are resisting arrest. That's the key thing. All right? And it comes about, as it says here, on a case-by-case basis. Let's look at this example. It says here that if a detective had been invited inside the home of a suspect to speak with him, and they speak to him face-to-face at the table in the kitchen, this wouldn't be an arrest because he was invited. They let him come in. So this is not an arrest, and it wouldn't be custodial questioning. But as soon as the officers brought 4 uniformed officers with them and surrounded the suspect on all sides at the kitchen table, creating a perception that he wasn't free to move, this could probably be an implicit custody. And why would they have them around him if they didn't intend on restricting his movement? And so at that particular point, then you probably are in custody, and the Miranda warnings should be given as far as asking any questions or information during that time. So it says law enforcement officers must be mindful of whether or not a person is under arrest, either explicitly or implicitly, because like I said again, Miranda will kick in. So now, how do you resist arrest? I already gave some, but assaultive behaviors toward police, such as punching, kicking an officer, resisting, putting tension on, that the officer feels that they need to place a person under arrest, where the force might be necessary, that they might feel like they have to take you down or stun you or something like that, not unnecessarily, but in a situation where there is some very serious physical resistance that comes about. And so resisting arrest and obstructing statutes are different depending on the jurisdictions. For example, the state of Tennessee says resisting stop, frisk, halt, arrest, or search outlaws resisting by stating that it is an offense or Class A misdemeanor for a person to intentionally prevent or obstruct anyone known to be a law enforcement officer or acting in a law enforcement's presence at the officer's direction from effectuating a stop, frisk, halt, arrest, or search of any person, including a defendant, by using force against law enforcement. So when they try to, the key thing is when you use some kind of interference in it, then you can obstruct justice, but you can more specifically, when a person is in an arrest mode, is that you can be charged with resisting arrest. It says finally, if a person in Tennessee uses a deadly weapon for resisting arrest, then it elevates, of course, to a class, is increased to a Class A misdemeanor. All right. So that's resisting arrest. Pretty clear on what I've shared with you. Now let's talk about fleeing. So what happens when you flee? Very simply, you attempt to escape, running or driving, and vehicle pursuits. We're going to talk about in just a minute. These are the ones where there's really serious injuries that take place, both to law enforcement and to other people as well. People are seriously injured or either killed. And all the time, it is important that people understand. Now, police officers have been injured and even killed during a foot chase. It says more police officers, innocent civilians, and suspects are seriously injured or killed during vehicle pursuits each year. But the foot chase, now, one of the things that the police cannot do is if you are in a foot chase with you and you don't have a weapon or a dangerous weapon, they cannot shoot you for fleeing. That is a violation of the law. Read the Garner case, and you'll know what I'm talking about. It is one of the Supreme Court cases that establish that. Very clear, all right? So let's talk about in a vehicle. So if you get in a vehicle and you're taking off and you're driving and the police have to go and chase you with high speed, they have sirens, flashing lights, and all of that. In those situations, the departments establish policies, and those policies must be adhered to by the police in terms of how they handle those kind of situations. It says, according to the State of Wisconsin Emergency Vehicle and Operation Control Instruction Manual, due regard is defined as degree of care that a reasonably careful person performing similar duties would act under the circumstances. Now, during the pursuit, there are a lot of things to take into consideration. Is it day? Is it night? What time of day? Is there a lot of traffic out there? What is the offense that the person, is the person charged with stealing a loaf of bread and takes off running, or a bag of candy, or something like that? Depends. The weather and the road conditions and the speeds that are involved, and then, of course, the driver's ability. But we were taught in the academy some very serious techniques, which we're going to just basically kind of share with you. But each agency has what we call police pursuit policies. And then there's a sample one given here, and I'm not going to click on it, but you can look at that sample pursuit policy, and you're going to learn something when you do look at that pursuit policy is there for the protection of innocent parties as well as the police that are operating in those pursuits. So the key thing is to minimize loss of life and maybe property damage. But loss of life is one of the premier issues that's involved. And there are various techniques that we were taught in the academy and that we're going to share a few of them with you here. Of called forced to stop or induced to stop techniques. And so here are some of them. Include ramming the vehicle, using a roadblock, and these kinds of things. Now, we were trained how to strike a vehicle at a certain angle so as to stop the vehicle so that the person would lose control. They also have, in terms of the roadblocks, there are usually some form of spikes that are put out as well to cause the vehicles to have flat tires. And then there's a box-in technique, and we share some of those. But in the United States Supreme Court, in the Scott versus Harris case, there are some facts that are involved in terms of the situation overall, and the Supreme Court laid out the rules. Pretty much, here are some examples. A fleeing driver suspected of a violent felony speeds to a 45 in a 30-mile-per-hour zone to elude. But the suspect stops at all lights, uses turn signals, which this doesn't hardly happen. These behaviors are not overtly dangerous, and ramming wouldn't be justified, okay? Because it doesn't happen. The same suspect, though, in that same scenario, at a higher speed, which is 90 miles per hour in the 30, so that's 60 miles above, makes sudden turns, drive through red signals, nearly hitting other motorists. In this case, ramming will be justified because we have to do something to get that individual to stop because they could end up killing someone. And that's pretty much what happened when you read the Scott versus Harris case. All right? So let's talk about the induced stop techniques. These are what we learned in the academy. And, you know, you deal with one I was talking about where, for example, here's the target. And so what your deal is to try to not hit the car on the side, but just enough to knock them off course so that they will then spin around. But it's called pursuit intervention technique. And this is just one of which. Now let's look at another one. Stop sticks. This is what I was talking about earlier. Devices that are placed in the path to cause the tires to deflate. You all are familiar with that. If you've been in a parking lot and they tell you, do not back up. If you back up, you know what will happen. Well, that's the same kind of thing that the police do. And I've been involved in roadblock situations where we use stop sticks, where we put them out that the cars come, and if they come and they keep coming, we move out of the way, they're going to have flats, and then that's going to slow them down. Partial roadblocks, where a squad car is halfway across an entire, leaving half of the road open. The goal is to direct the fleeing suspect into the open area, and then in those areas, stop sticks are usually put there to force the individual to drive over the stop sticks, and you know what happens then is what I just got through talking about. Boxing in, this is a technique where there are vehicles on all sides, and it causes the individual to come to a stop. And then, of course, it says a suspect who is highly motivated to escape could ram any of the vehicles to escape. If the suspect is armed, this maneuver puts some of the squad, especially those in front alongside, directly in the line of fire. So these are techniques that you have to use in the right situations in the appropriate times. And so these are some techniques. And the key thing that law enforcement is trying to do, again, is to slow the individual down or stop them. All right? So now we're going to conclude. I think this is the last section. Yeah. And we're going to deal with disorderly conduct. Now, there's a video here that I'm not going to play because the video is 35 minutes, and we got 6 minutes more in this class. Feel free to look at this at your own leisure. Here's the key thing. What is disorderly conduct and what is free speech? Well, the First Amendment protects freedom of assembly, religion, press, and speech, and allows individuals to peacefully protest, to assemble, and to use picket signs or to march against a cause. But the First Amendment protects free speech, but not all speech. The First Amendment, as it says, was intended to promote the idea that you can speak freely, okay? But it must be in a peaceful and organized fashion. Any speech, hear me people, that is designed to inflame another or create a physical confrontation or result in what we call fighting words could result in disorderly conduct or breach of the peace. And you could be arrested for that. Shouting of obscenities that is likely to cause a breach of peace. Now, for example, let me say this. You can shout obscenities, but if you shout them at someone, especially in their presence and they're in a close proximity, then we're getting into the disorderly conduct. Just expressing profanity itself may not necessarily create that issue. As you see this lady here, she has a megaphone. So it depends on what she's saying in that megaphone. And as to what that police officer might or might not do in terms of charging that person with disorderly conduct. It says here clearly, and this is the best way I can put it, is to read this, and then I'll comment on it. Every person who maliciously or willfully disturbs the peace or quiet of any neighborhood, family, or person by loud or unusual noise, or by tumultuous or offensive conduct, or by threatening, traducing, quarreling, challenging the person to fight, or fires any gun or pistol, or uses vulgar, profane, or indecent language within the presence of the hearing of children in a loud and boisterous manner is guilty of a misdemeanor of disorderly conduct. And that's an example, some examples. That pretty much goes across the board. And so we deal with issues where individuals should understand what is it that we're doing. We're just controlling and trying to maintain order, and that's pretty much it is. There's a balance between what you can say and what you can do. For example, there are certain actions that not say anything that could still result in disorderly conduct, such as burning a cross, the Ku Klux Klan symbol. You could go to jail for that because that's a speaking activity, even though you're not saying it with your mouth, but your actions are speaking clearly about what you're doing. Okay. At the same time, the Ku Klux Klan can march in areas where hostile areas, such as I remember some years ago, there was an area in the north called Skokie, and there's a lot of Jewish people there, but they wanted to march the Ku Klux Klan in that area. Well, they had to go through the proper steps to get the permits, and the permits were there to provide the actually the protection for those individuals to be able to conduct those marches. And so the First Amendment allowed them to march peacefully. They didn't. I bet they wouldn't go through Inglewood. It probably would be a good move. And many people who know Chicago know what I'm saying when I say that. Black's Law Dictionary, which is a dictionary that many of us are familiar with that are lawyers and learn about it as law librarians and in law school, defines a riot as a tumultuous disturbance of peace by 3 or more persons assembled together with the intent to mutually assist each other against anyone who could oppose. And riots are designed significantly to trigger violence. create property loss and things of that nature. So again, you can learn more about that by looking at this. All right. So that's it. I want to go here and show you again some things that can help you to summarize the materials that I've lectured about, as well as the materials that are in your textbook, as well as the materials that are in your PowerPoints that I shared with you. And you use these to help you to prepare for your final exam, which is coming up. You know, you had one in week 3. That was for weeks 1 through 3. The next are going to be for the weeks that follow, which are 4, 5, and 6. Okay, so let me move this out of the way. Let me get it out of the way. Let me see. I should be able to bring it down. There we go. Okay, let's move Joel out of the way there. So here's some of the things you can do with flashcards. Custody that is less clear and is concerned with what a reasonable person would believe at the time of police encounter. So then you flip this over and the answer is given. Implicit custody. We talked about that earlier. In other words, it's made, like for example, that person that's surrounded, then it's clear that that person is not able to go. Custody that is clear, very clear, and leaves little room for error or misinterpretation, that you're under arrest, or explicit because it's made clear by the circumstances as well. But it is very clear, usually like you're under arrest or you can't go. Using physical force to resist lawful arrest, and you know what that is. That's resisting arrest. Then you go to the next one. Deliberately misleading police or withholding information that prevents government from effectively and efficiently investigating criminal matters. Here it is, the old word, obstruction of justice. And so you go through each of these, and you can test those out, all right, to get ready for your exam. Again, same thing applies to the practice for free speech or disorderly conduct. And you go through the same kind of exercise, but you have a little scenario. So you start the activity. A man is walking in the middle of the street in a busy downtown entertainment district, yelling profanities. Is this considered free speech or disorderly conduct? What do you think? Type in the box which one you think. Free speech or disorderly conduct? Disorderly conduct? Okay, let's try it. Yep. Disorderly conduct because the man used vulgar and profane language in a public place and his action would likely create a breach of the peace. Now, there are some arguments, though, that could be made that if he was just yelling it out and he wasn't yelling at an individual. So it's a case-by-case basis, but in this scenario, I think that here's what you need to be careful of when you're taking these tests, is the general, don't get too deep, over-analytical. Myself, I can present some situations where that may not be disorderly conduct. However, just remember this. You're not going to have that leeway in terms of the test. Think in terms of what would be the most direct answer, and that would be disorderly conduct. Abortion activists are standing on a street corner holding signs of aborted fetuses that some citizens have cited as offensive. Is this considered free speech or disorderly conduct? Which one? It is absolutely correct. because of the fact that, that's exactly what it is. They're not vulgar or profane. People might not like it, but that's exactly what it is. Do one more. Edwards is watching a movie with some friends inside a theater. Oh, I know about this one. That is half full. He says to his friends, watch this, and yells, fire, causing 10 patrons to run out of the theater. One patron calls police and complains. Is this free speech or disorderly conduct? It is definitely disorderly. There's a famous case, and I can't remember the name of it. It's a constitutional case that says you cannot yell fire in a crowded theater. I don't have my thing here. I could look it up. But if you Google, it says the case that says you can't yell fire in a crowded theater, it would pop up. So, yeah, it's disorderly conduct because his actions could create serious injuries and or death to others. So those are the kinds of things that you do with that. Beneficial to help you. It's not just game playing. And then we come down to the all-important practice quiz. Don't forsake the other two. Do all of them. But this is just like what you ran across before. A local resident, and I'm not going to answer, I'm going to let you answer it. A local resident is suspected of setting off a truck bomb at a religious temple, intentionally targeting the parishioners. This is an example of what? Well, oh yeah, we know that. We know that all of them say terrorism, but which one? Okay, and you say domestic. Let's see. You're right. Because it was carried out by terrorists who are from within their own country, because that's why that word local resident was in there. Okay, and that's the clue. So yeah, good point. Let's do one more. A foreign national living in your community is part of a terrorist organization from another country and intentionally blows up a city hall building to avenge the death of others in this country. This is an example of what? Which one? You say international? Let's try it. Because it does say a foreign, okay, let's see. You're right, because it gives you enough information there. Some people might say it is not, but no, they give you this little biscuit of foreign, like the earlier one. Living in your country is a part of a terrorist organization of another country. That's when you start getting into that kind of stuff. Do one last one. You stop a man that you believe was about to break into a store, but stop when he saw your marked squad car. You question him and he lies about his name. What will you place him under arrest for? You're going to be wrong. It's obstructing. Remember this. Lying about one's arrest is obstructing. Did it say that he was under oath? Yep. Yep. If it said a person was under oath and did it, then we start talking about that. You got to remember, watch that part. A police officer is testifying, there we go, see, under oath about an arrest that he made and lies about the reasonable suspicion that was used to make the stop. What criminal law was violated? Now your turn. Okay. All right. That under oath thing kind of like lays it out for you there. Just remember, when you're taking these tests and these quizzes, they're going to give you what we call a biscuit, and they're going to give you something that will generally guide you in terms of going that way, one or the other. So that's one of the things that you want to look out for. Okay. All right. Well, I thank you, Joel. Good to see you again. This is one of my students from uh, several of my other classes who did pretty well, and he also did something very special to help our church, and we appreciate that as well. Thank you. So tonight, before I leave, I just want to give you one word that is a violation that creates a big problem that we have, and that we are undergoing constantly is called domestic terrorism. That's what I want you to give me, and you can get your points. So with that, I'm going to say good night. It's storming outside here, so I'm about ending at the right time. Yes, and so I'm going to say good night, and thank you for coming out, and I'll look forward to see you next week at the same time with week 5. Time's winding up, so good night.